Morning, everybody. Welcome to this IIRSM session all about data privacy. I'm going to hand over to Alison, who's going to chair this session for us. Alison, I'll hand over to you. Do you want to do introductions and so on?
Okay, thank you very much, Helen. Yes, just a few housekeeping things. Questions. We're still looking for questions, so please, if you have any, write them on the chat, and I'm going to read them after we've had our introduction session. Thank you very much for joining us for this IIRSM webinar. Today we're looking at an in-depth discussion on what GDPR means to us. So you will probably, hopefully, have seen the first of the discussions, which we did a month ago, and that's on YouTube, and that a link to that will be sent out together with the link to this webinar afterwards. Very, very pleased to have back Helen Barge and Anna Walters from Risk Evolves Limited, who shared their expertise with us last month. I had such good feedback about it, so thank you for that, particularly on how you took a really complicated subject and just made it understandable, sort of brought it to life. So it was clean and simple, but very comprehensive. Thank you. Also, we have here today John Nelson, who is a health and safety manager at ISG. He has a construction role there, for a company that's looking at the design and build of data centers. So thank you very much, John, for joining us and giving the health and safety manager's perspective on this subject. John is also a trustee for IIRSM, so great to have an opportunity to meet you for that as well. Thank you, John. Okay, shall we, I think we're going to start with a quick refresh of what we went through a month ago. So I'll hand over to Helen and Anna to take us through that.
Fantastic. So thank you, everybody. Welcome back to another session on GDPR, but this time GDPR with a very strong flavour of health and safety as well. So Anna and I thought it'd be really useful just to spend, we promise, no more than 10 minutes just doing a really quick update on what the principles are of the GDPR and so on. One slide there, these slides are going to be available after sessions, so and they will be sent out as well with the email. So, and if they don't, then please contact IIRSM and I'm sure they'll be reissued. The video itself will be available on the YouTube channel as well. So a little bit about the IIRSM there, a very large organisation and growing, and I'm sure John can actually speak a lot more eloquently than I can about the structure and shape of IIRSM. But as you can see, it's a global community. So Anna, I'm just going to hand over to you now. And we touched on this last time, didn't we? What is data protection?
Didn't we? And I think, you know, one of the things, Helen, that you and I pride ourselves in is kind of trying to make things feel a little bit more simple, because data protection can feel so complicated. And I think it's always great at the beginning of a session just to take that step back and remind ourselves that actually data protection is, as it says there on the screen, purely the process of safeguarding important information such as personal data from all those threats that are out there, such as theft, corruption, lots of unauthorized access, corruption, compromise or loss. And I think we all do data protection in some senses without even thinking about it. So when we're locking our computers, you know, when we walk away from them, when we lock that cabinet in the office, that kind of thing, that's all leading towards good data protection. So I think it's really easy sometimes to get lost in the complexities of it. We need to take that step back and remind ourselves that actually it's purely that simple process of safeguarding that information.
Perfect. And why do we do it? Why is it important? I know this is what you're really passionate about, Anna.
I am, and do you know what? My original career, I started in data analytics, so I'm all about, my passion really is all about using data and telling stories from data. But you know, many years ago, I kind of made that connection with the fact that data privacy is a human right. And John, when we were talking just before the session, you reminded us the importance of having that strong moral compass around the use of data and people's data, and we must all remind ourselves that data privacy is in fact a human right under the European Convention of Human Rights. You know, we've got many human rights, and the right to privacy, the right to a private and family life, is written into those human rights laws. So, you know, whenever we're thinking why is it important, it's important because it's important for our human rights.
And what we were saying, wasn't it, just before that we came on this call, we were just chatting and doing a little pre-warm up, if you like, in our green room, was very much, this is around not just the rights for here and now, but also around how data may be used in the future as well. So making sure that data is kept safe for now in the future. Oh, this is a busy screen. I am not going to dwell on it for too long, but this is what we mean by personal information, isn't it? This is just some of the categories that we see. Do you want to just have a quick squiz through, Anna, and I think really focus on the special category data, because I'm suspecting that special category may be especially pertinent for the health and safety community as well.
Yeah, absolutely. And so there's two types of personal data. There's the personal data that we all completely understand: name, date of birth, address, those kind of things that can identify us directly. And we move then into special category data, which is all those things that feel a little bit more sensitive to us, that if our own sensitive personal data was exposed or put at risk in any way, that we would feel a little bit more uncomfortable about. So we're talking here about that kind of ethnic, religious, health data that talks about our political opinions, information about sexual orientation, all that health data that we share. We might share that with with HR in our teams, and we might share that with our doctor. Those kind of things that are a lot more sensitive to us become what's called that sensitive personal data. And under the GDPR, under the data protection regulations, that needs to be kind of looked after and taken care of in a much stronger way, potentially, and have some really strict controls about it. So yeah, so that sensitive personal data is what we're kind of here to talk about. And so it's things like those sickness records. It's those kind of things like, if we think back to the COVID days, any data that we might have collected from a COVID perspective, test results and vaccination records and those kind of things.
Hold that thought. I think that's one of the questions we've got a bit later, Anna. So fantastic. Right, what else have we got? Privacy principles. We love principle-based legislation. Again, we were talking about this, and I'm just going to do the reveal of all the principles. Oops, let's just go back one. There we go. So we spoke about this very briefly, didn't we, Anna, last time? And I like your summary. I love your summary, because I think this just brings it all into perspective. We could do the very formal one around transparency and fairness and so on and so, but this is about quickly run through those principles.
Yeah, absolutely. So, and Alison, it was really interesting when we were in our little green room preparation earlier on, and you mentioned that you really liked the fact that the data protection laws were principles based. And the importance of that means is it gives us that flexibility to decide how we apply those principles in our organisations. And my English translation there of the let's just say the wordy principles in the regulation means that all of us need to make sure that we're really honest about what we do data. We need to be transparent about it and tell people what we're doing. And that, you might giggle, but I always go, and don't be creepy. We all have that sense of, ooh, should we really do that? And if we have that kind of thought, if we want to do something with someone's data and we have that thought of, ooh, I'm just not sure, that face that the garage pulls when you take the car in. Ooh, if we're pulling that face when it comes to what we want to do with personal data, then it means we might be being creepy with it. So just take that step back and think, should we do that? Make sure that you've got a really strong reason for having that data and using it in that way. Collecting only what you need. Us humans love this, don't we? We go, oh, well, we might need this in the future. I'm just going to keep that, or I'm just going to collect it. So the data protection law doesn't necessarily allow us to do that. We only really are supposed to collect what we need to do the job. Make sure it's correct. Now, that's kind of common sense, isn't it? If I put my data analytics hat back on, why would I want data that isn't correct? So make sure that the data that we do have, if we collected it a little while ago, what are those checkpoints that we have to make sure that we're still keeping that data correct about somebody? Don't hoard it. We love hoarding as human beings, don't we? We love going, oh, I'll save that for a rainy day. And this always creates a lot of discussion, doesn't it, Helen? Well, how long am I supposed to keep data? And actually, the data protection law only says to us we're only supposed to keep it for as long as we need. Well, how long do we need it? And actually, those answers are in lots more legislation. So it may well be, here in England, here in Britain, we've got the Companies Act, which tells us how long we're supposed to keep certain types of data. Health and safety laws tell us how long we're supposed to keep accident records and those kind of things. So to answer those questions, we often look to other laws to help us answer that question. And then the final one there, keep it safe. Why would we not want to keep one of our most valuable assets in the organisation safe? So we need to make sure that whatever we're doing, we've got those security protocols around it, be those technical or be those human related, such as locking doors and those kind of things.
And the accountability principle I love, because I think this has got a really strong parallel with what happens in the health and safety world as well. Somebody has to be accountable for health and safety. Funnily enough, somebody has to be accountable for data privacy. So this isn't just something that any organisation can shirk or can say it's nothing to do with them, or it's somebody else's responsibility, or it's down to the IT department. Data privacy has to have an accountable individual somewhere within the organisation. So those are the principles. Just very quickly looking at the lawful basis, we've only got 6 legal reasons why we can have data. And again, I'll just do the reveal there. All this is on the previous webinar that we did. Anna, do you want to have a quick squeeze through the and summarise what the lawful basis are?
I can do, and this is one of those biggest myth-busting things. I love a bit of myth-busting. There's a lot of myths out there that we all need to have consent to do something with somebody's data. And that is an important, one of the important lawful basis, that if we want to do something, we can ask for consent. But it's not the be all and end all. And actually consent can be quite limiting, because if somebody then withdraws their consent, then we have to stop doing it. So we have to be very, very careful around how often and when we use consent to do something with personal data. The other 5 reasons are if we've got a contract and what we need to do with somebody's data is necessary to perform that contract, either with them or a third party, then we can process their personal data. If the law tells us we need to as well. So of course, if the law says, well, you need to do this, such as keeping health and safety records, then you have a legal obligation to do it, and therefore you can go ahead and do that. If you want to process, if you are in a situation where you need to share somebody's personal data, let's say in an emergency, to protect their life, such as if there's been an accident and you need to share their data with let's say, the emergency services or occupational health or something like that, then we can do that potentially because there's a vital interest for that person. If we're doing something that protects their life, protects their health, then, but it must be in an emergency situation. That one, it's quite specific. Public task is actually only available to organisations who are responsible for kind of public operations. So we're talking here about local authorities, police, schools, those kind of things. If you are tasked with doing something for the benefit of the public, then you can do something with their personal data. So an example of that actually would be CCTV cameras on the streets. They are recording our movements, they're recording our registration plates and those kind of things, because there is a public task to be done. And then this is the one that if none of those 5 match what you want to do, then if you need to do something that's in the legitimate interest of the organisation and that doesn't outweigh the human rights of the individual, then you can potentially look to do that under legitimate interest. So some types of marketing can be done under legitimate interest. Things like, a lot of health and safety work can be done potentially under legitimate interest for the processing of personal data, because it's in the legitimate interest of the organisation and the individual concerned.
And then finally, our data subject rights, the rights that we all have.
Oh gosh, do you want me to do a quick one on this one, Helen?
Really quick.
So we mentioned at the beginning that data privacy is one of our human rights, and the way that we can exercise those rights is through these 8 rights that we are very specifically given under the data protection laws. So we have a right to be informed about what an organisation is doing with our personal data, and if we match that back to the principles, if I remember, I said that we have to be honest about what we do with people's data. That's how that principle matches up with our right to be informed. So as an organisation, you will have a privacy policy, which is usually available on your website, and that's how an individual can then choose to be informed about what they're doing. So we've got the right to be informed. We've got the right to access our personal data. Now it's quite interesting, this one, because, and this one's very close to my heart. So we've heard of subject access requests, many of us, some of you on the call may be going, oh, I don't want any more of those. I've dealt with personally about 500. So subject close to my heart. So we have the right to ask for access to our personal data. We don't necessarily have the right to see all of it. There are some exemptions that mean some of it can't be disclosed to us in certain situations, but we have the right to ask. We've also, if we think back to the principles, we've got that principle of keeping data accurate. This is then reflected in our rights by the right to rectification. If our data isn't accurate, we can ask for it to be rectified. We can also ask for it to be removed and erased from an organisation, but they can only do that if they no longer need it or shouldn't have had it in the first place. We've also got the right to port it to another organisation. A lot of industries already do that. So if we think of the energy sector or the medical profession, if we move to a new doctors, then our health records go with us. If we move to a new energy provider, our energy data moves automatically to the new provider. So some of that already happens. We've got the right to restrict processing. So if we want to temporarily ask an organisation to stop doing something with our data, we have the right to ask for that. But it's time bound, that it can't be forever. We've also got the right to object to automated decisions. So, you know, those times when you're kind of looking to apply for a mortgage or a new credit card and you put all your data in and you get that nice little whirly wheel that says waiting, processing, and then spits out an answer and goes, computer says no. You've also got the right to ask for a human review of that decision. And you can, in some scenarios, object to the use of your data. This mainly is around the use of it for marketing. So if you're getting spammed by lots of marketing, you want it to stop, you can actually object to the use of your data, issue them with an objection and say, stop doing it, stop doing it. Was that a whistle-stop tour, Helen? Was that?
That was a whistle-stop tour. That was a whistle-stop tour. Well done, Anna. And breathe. So if anybody is interested in finding out a little bit more, as we said, then that is actually available as a webinar, which was recorded last month and is available on the YouTube channel. So Alison, I'm going to hand back to you now whilst Anna has a quick breathe.
Thanks, Anna. Yes, bit of a drink. Right. So John Nelson has joined us today as the health and safety expert and giving his perspective on data protection and holding data. So, John, can we just ask you quickly to give us your thoughts on the subject?
Yeah. I'm challenged already when you say quick. My answers are never short, and Helen probably knows that. I think my perspective really is, and I guess I'm going to wear a couple of different hats. I think first and foremost, you know, as a father, you know, I have changed my perspective since becoming a father, and all of a sudden I'm much more cognizant of somebody who I'm responsible for, who is vulnerable. And that opens up that whole kind of vulnerability piece in terms of, and I think COVID has kind of confirmed that there's so many scams out there nowadays. You know, this is about it's about protecting people who are vulnerable. The human right, absolutely, but you know, if you take it back to that whole kind of moral compass, that gives me perspective as a father. As a health and safety person, and sometimes wearing a kind of quality hat, you know, for me, there's always been that kind of emotional attachment to, for example, things like investigations, be it an near miss, an accident where someone's been injured, or maybe even worse than that, there may be a fatality or multiple fatalities. And I think it's always a challenge trying to make and keep it personal, because you want to talk about, you know, the injured person, you want to give them a name. I think you should do so, but the challenge is, you know, where do you stop without giving too much away? And that's difficult to get that fine balance, because it's important to, you know, to give and share relevant information without obviously going one step too far in terms of GDPR and the whole data privacy, data protection. But then also to wear my trustee hat as from the IIRSM, and this kind of confirms a few things already. It's that kind of governance piece. You know, it's all about ensuring that, you know, that organization is protected and everything it does. And that's probably the quickest answer I can give you, I think.
Oh, Alison, we've lost your sound.
I think we've lost your audio.
Sorry about that. What you said about keeping it personal, that really means something to me, because I spend a lot of time trying to encourage people to take care of health, safety, environment, quality issues, and if it doesn't relate to them, then they just tend to look the other way, and so I do try to make it as personal and meaningful as possible. And yeah, I really can see the clash there in the two things. So yeah, thanks. That was meant a lot for me as well. Okay, right, I have a list of questions in front of me. I'm still hoping that some people on the call will also ask questions, and then I'll put them to the panel. But let's start with this one. What do the panel perceive as the key risks in achieving compliance with the various pieces of regulation around their organisations? And I think, if I may, can I start by asking John that?
Sorry, I didn't quite catch all the question, Alison. Sorry.
What are the key risks in achieving compliance with the different pieces of regulation in your organisation?
Within my particular organisation, there's a risk associated with what we do and where we do it. We're an organisation that works globally, or certainly probably 3/4 of the globe, so internationally. And I myself am typically involved at the moment across projects from the UK, from Portugal, from Spain, from Belgium, and also from the Netherlands. So thereabouts. So, you know, one of the risks is actually understanding what, and I'll use the term point of reference. So what is that point of reference? So what is the legal requirement I and the organisation needs to meet as a minimum? That's the key thing. Fortunately, I guess within Europe, we've got commonality in terms of what we're doing. But even still, how you interpret that and how you apply it on a country by country basis is one of the biggest risks. And you know, and so often there are subtle differences. So for example, you know, even working in somewhere like Belgium, you know, when you've got a country that has several territories, they may have subtle standards that you need to adhere to as well. That's one of the key risks. Then it's also about how you go about then capturing information, and then how you then think about, okay, how do we use this from the perspective of a health and safety perspective, in terms of trying to do the right thing and stick to what's required to do so, to fulfill that role, that purpose from a safety perspective, but equally making sure that you are still being compliant with all the other requirements under GDPR, the applicable legislation. And that brings in things such as, you know, Anna mentioned then one of the special categories around biometrics. You know, typically on a construction site, you may have a turnstile, you know, to get people in, get people out, and keep people in, arguably. You know, in terms of then what that kind of access control requires and what information it's capturing, it's then that's one of the risks certainly we're faced with as an organisation. But then typically that turnstile, it's not ISG property, it's another organisation we've partnered with for that physical control to the site, and therefore it's going through the process to make sure that organisation, as a partner, as a supply chain partner, you know, going down the route in terms of second and third party vendors who may also have access to that information. And I recall conversations, I'm probably going back 8 or 9 years now, thereabouts, you know, in terms of, you know, this whole kind of first talk about physical access control, biometric, you know, someone's getting to site using a fingerprint, etc. And all of a sudden, what that then takes you to, and where that information could then go to. Those for me are the key risks. And then you kind of move on from that in terms of, you know, okay, well, we've got to capture people's information for the likes of, you know, understanding who's on site and understanding, you know, if something untoward was to happen, even if it's not related to actual work activities on site or the environment, you know, for example, someone may have an allergy to some kind of food. It's then how you first of all request the information, so you've got knowledge of that as a first responder or a first aider, but then equally, you know, once you've got the information, what you then do with it if that situation then does arise. So, you know, for me, you know, you typically go through a process in terms of, and a control process to identify and confirm what those key risks are. Hopefully that gives you a feel for my starting point in terms of a systematic and logical approach you would kind of apply, certainly.
Yeah, it certainly gives a feel for what a huge job it is. Helen, what are your thoughts on this?
Echoing everything that John has said, we work with a number of both small organisations, we work with a number of global organisations, and one of the challenges is understanding the regulations within country. So how does the privacy regulation interact with the health and safety legislation, interact with all other types of legislation? And then you have to expand that to, well, how does that then work with the global legislation? How does that work with local deviations? How does that work with local rulings? So we've obviously, from a privacy perspective, we've got a number of different supervisory bodies throughout Europe and you know, into the UK as well. So if they issue guidance, is that guidance applicable for all the other countries as well? We've got new legislation coming through, again, from a privacy perspective in many other countries. So I think the challenge for every organisation, and I will say it is a lot harder for smaller businesses because they don't have a legal department, for example, is just keeping up to date with it all, because you're absolutely right, John. It's not easy. It's not easy. It is incredibly complicated. And I think the risk for many organisations is tripping over all of that.
And do you have a suggestion for how to do that? How to keep up to date?
I will say calls like this actually is one of the things is around collaboration. This isn't, for me, this isn't about a competitive angle. This is about collaborating. What are the best solutions out there? Is there, you know, a forum where you can come where you've perhaps seen a new piece of legislation? Is there a forum where you can come to where, you know, you spoke about biometrics on sites, John. There was a case in the UK where the site manager was using facial recognition for people that were coming and leaving site, and actually was picking up facial recognition of people that were passers-by. Now, the Information Commissioner in the UK got a little bit upset about that because, and it was just the way their cameras had fallen. That created a lot of debate within the UK. The case is on the Information Commissioner's website and is very easy to access and so on. But it's just that thought, that stop and pause moment. If I use this, why am I using it? What's the data I'm capturing? Why do I need it? Who's going to use it? How long am I keeping it for? All the things that we spoke about on the last call. And am I accidentally going to pick up the personal information of somebody else? So.
I think the one thing I would add to that, Helen, and John, I wrote down here, you used some really good words there, structured and logical. And this is where there's some really good alignment between the privacy legislation and the health and safety legislation, because with the health and safety legislation, you have to do risk assessments and that kind of thing. And the privacy legislation encourages us to do something called data privacy impact assessments, where the considerations that Helen just mentioned, we're able to do that in a really structured and logical approach. And wherever you're based, your local data protection supervisor authority. So for here, for over here, it's the ICO. They have a brilliant template that we can use to step us through those questions. So that, and if we align those questions then with the health and safety risk assessments, I think that will then gives us the opportunity to almost kind of ask all those questions in that structured and logical approach, and consider all those risks at the same time as those health and safety risks.
Yeah, I think something else just jumped to mind there in terms of one of those risks. It's about how long we hold the data for, because if you think about in the UK in particular, I know it's not about you being UK centric, but UK in particular, there's a kind of timeline in terms of if somebody wants to let's take a civil suit in terms of someone's looking for some kind of compensation, seeking damage of some kind. There's a time frame for that. But then when you start to introduce contract law to it, and not just contract law, but also a specific contract for a particular project, etc., that can take you up to 15 years in some cases. And the quandary then you have within an organisation, with your client organisation, is, well, should we really still be holding this particular data? Is it still relevant? And a lot of my experience from a client conversation has been, we don't want to throw it away, which is your point earlier. And we tend to store stuff or have all this clutter, which, yeah. morally, I think, oh, I'm not so sure, but I don't think we do, and I go qualify it somewhere else. But we've still got those conversations that are taking place in terms of how much we have to hold it for and how long, and that's one of the challenges, certainly. But I think also,
one of the things. No, sorry, go on, John.
No, I was going to say as well, I'm going back several years now in terms of, if I think from a health and safety perspective, we think about the Social Security Act in the UK, and that kind of, you want to promote people to report accidents and near misses, etc., because it's good, it's helpful for the organisation. Regardless what debates are out there about it nowadays, is, so therefore I would champion, and as a safety rep at one time for a trade union organisation, I would champion, actually, if I can't do it as the injured person, somebody else on my behalf can do it. So that whole kind of debate then in terms of, well, can somebody else really report the accident because they then your data and it's feeding in somewhere. But it's been around for many, many years, and I think one of the challenges, arguably, although it's opportunity for safety personnel, is to change that habit in terms of, we want to make people aware of what's happened, but equally it's a thin line between actually what you can share, regardless of what could happen from a criminal perspective. It's still a thin line, because you want to still make that emotional attachment for people to actually buy into what we're trying to do and why we do what we do.
I've got a question here from Dominic that sort of leads on from there. Which of the 8 data subject rights under GDPR are most likely to be weaponized against a company, and should these rights be changed? I think he's obviously been watching Anna's. Start with Anna on that one.
This is an interesting one. Having dealt with so many data protection rights, I don't see very often the rights being weaponized. I think, there's definitely, I remember, that there's often that kind of conversation about, well, why have they put in that subject access request? They're just doing it to annoy us. And actually, if that does happen, the legislation allows us to actually say no and say, do you know what, if we do have that evidence and we do have that feeling that actually that right is being used in an inappropriate way, we can actually say no and just say, look, do you know what, actually no. However, in pretty much all of the instances where I've supported with data rights requests, they've all had a really strong reasoning behind them. I mean, let's be honest, certainly, the rights, when I see subject access requests come in, they're never done when people are happy. They're always done when there's a conflict situation, which means that people receiving feel like it's like, oh my gosh, don't me right now. However, if we then take that step back, and anybody who's ever either been involved or going to be involved in servicing somebody's rights request, always remember that your role is to be an advocate and a voice for that person. They're asking for a genuine reason the majority of the time. So, so if it's being weaponized, you can say no, but in the majority of times that I've seen and certainly supported with, they're being asked for genuine reasons. And if you are on the receiving end of one of those requests, remember it is their human right to ask. And you must always respond in being that kind of advocate and that voice for that person, going, okay, let me help. What do you want to know? What do you want to find out?
And just to echo that, and in probably about 95% of the situations, Alison, that we see these, and Anna's absolutely right, it typically is the subject access requests we see most frequently. It's where the relationship has broken down. It's either the client's relationship with the customer, business relationships broken down, or the employer-employee relationships broken down. Something has gone wrong. People don't do these just for the sake of doing these. We've not come across, I mean, we've processed now several thousand of these for clients. We don't see these being processed as a weapon. These are typically because somebody's reached the end of the line. They've just gone, I don't know what else to do. Help me, help you to help me, and certainly not weaponized.
Do you have any experience of this, John?
Not so much around that, but I'm certainly aware of cases where I've been a hiring manager and such like. But I think what springs to mind, and if I think about when I and Helen first met, It was around information security and risk management for a particular organisation, and you know, the whole conversation around the physical security of information and data that you hold, and that kind of habit of actually clearing your desk when we always to go into the office and not work from home, in terms of how much information would be lying around. You know, and I look back up personally, and I can recall, you know, I probably did leave an accident report or an investigation report or an audit report or something on my desk hard copy, because I tell you what, when I come back in tomorrow, I'll red pen that and just get it finalised and what have you. And that was something historical and a habit we have to change. So in terms of going back to the question, in terms of my experience, it's more around, you know, leaving information and data around whereby anybody can access to it. So that whole kind of physical control, why it's hugely important. And it's not a case of someone's being malicious, but you know, all of a sudden, if someone's got 2 weeks notice and they're just working the notice, but they're still in the office and they go into a competitor, it's that kind of, you know, I might just take that with me. It's all kind of those kind of moral that we have to challenge it and be aware of, and it's how you do so. That's the challenge.
Yeah, I kind of read the question slightly differently, and I agree with what Anna says. It's when a relationship has broken down between an individual and the company, and they think, what can I do to damage the company as I walk away? And actually, they know that these requests for information cause an enormous amount of time, expense. And I guess the thought is, you know, if you're feeling a bit malicious, are there examples of that sort of thing? But you know, Anna's already said that she hasn't. Would you like to add to that?
I mean, I think one of the things that I've just kind of been thinking about here is I'm trying to kind of bring it back a little bit into the health and safety sphere. And if you do receive a subject access request, and let's say it's because, let's say there's been an accident and somebody wants to know about, well, how was the investigation run? And often there can be that I'm looking for the smoking gun of something that went wrong, because I then want to take some litigation action against an organisation. And I think one of the things I would add is there's a lot of fear around subject access requests, but it's really, really important, if you receive one where you believe that there's some litigation then coming, be very, very cautious about making sure that you understand what data you don't need to share. Because if there's legal action coming, while I mentioned earlier that the right to access your personal data is there, as an organisation, it's not there to be used against you. There are exemptions at play that mean if you know there's litigation coming, and there's if any sharing of personal data would prejudice any of your defence, any of that situation, then it isn't disclosable in a subject access request. So I think if you're faced with a subject access request where you've got pending litigation due to an incident or an accident or something like that, make sure that you revisit those exemptions and ensure you're only releasing what you need to do that isn't then going to prejudice your position. So I often like to bring it back to that, because a lot of organisations, certainly that I deal with, often feel that the legislation is almost there against them, and the legislation is not there. It's there to protect everybody. It's there, not just to protect the human rights of the individuals, but also to protect the organisation and ensure it shouldn't be seen as a barrier. It shouldn't be seen as that's something to be fearful for. It is there to protect you. I was working with a client recently who really felt quite, that they'd had a subject access request, and they were like, but we can't release this, there's litigation coming. I'm like, absolutely. The law doesn't mean you have to release it. You can actually take those steps to protect yourself and make sure that what you release doesn't prejudice your position. So I hope that helps as well, gives some kind of reassurance that actually the law is there to support.
But you need to have that knowledge about where the barriers are. What do you have to give? And then that's when talking to an expert is I guess the way forward. Yeah.
And
okay.
Alison, just coming back on that, certainly if you are an EU, if you're based in the EU, then every one of the supervisory bodies within the EU is incredibly supportive. So whilst we have a regulator in each of the countries, and clearly they have to help and make sure the law is followed. They have a friendly side of them as well, which is if you have these questions, just contact them. The ICO here in the UK, CNIL in France, the Supervisory Authority in Ireland are absolutely brilliant and will provide help and guidance. So don't be frightened to pick up the phone or use their chatbot or whatever. They're brilliant.
That's interesting to hear. So it's a bit like the HSE helpline, where you can do it anonymously and things if you're worried.
Yeah. Good. Can I just add that? I appreciate bringing us back to the question also, is in terms of, you know, I think when an enforcement organisation comes asking questions, for whatever reason they're asking questions, is sometimes you'll find some people wanting to give them anything and everything that they think is relevant. It's the same way if somebody, you know, lots of people are fearful of auditors. No, it doesn't matter what diagnostics you're applying, people are fearful of somebody asking questions, typically, I guess. And, you know, sometimes you want to tell the auditor anything and everything, and that presents a challenge for lots of people, not just safety people, but in terms of what information should I be sharing here? What information should I not be sharing? And for those particular reasons as well, which Anna's touched upon, that's one of the challenges I think faces us all as different practitioners in different disciplines.
Okay, let's take a step away from that and look at something practical for a health, safety, environment manager. So you talked about sensitive special category data like health data, and obviously as health and safety managers we have access to this. So I have a few questions on this. The first one is, during the pandemic, we captured data on temperature, staff illness and vaccination status. How long should I be keeping this data for? And I've also got one on what do I need to consider if performing drug and alcohol tests for staff. I guess health surveillance falls into the same thing. What additional precautions are necessary for holding this data? So just taking it all as one big question, what should health and safety managers be doing for this special category data?
I think
over to you, Anna.
Oh, do you know what? I knew that was coming my way. So I'm going to take the COVID one first, because actually it's quite an interesting one, this. So, I mean, I don't think any of us really want to rewind 3 years, but let's just do it for the sake of the question. When we were, certainly here in the UK, businesses were asked by the government to process, you know, to collect certain information. And you know, certainly organisations like the NHS and care organisations were asked to provide their vaccination status, and that was because it was a legal requirement. So if we did a very quick revisit, you can remember, I'm not going to say pull the slides up again, Helen, but we had those 6 lawful purposes that we could use somebody's data, and at that point in time we were collecting that data because we had a legal obligation to do so. Those laws have now been rescinded. So we don't have that legal obligation to collect and process that data. If we want to retain it, then we have to have found a new purpose for it. And that's quite a tricky one, actually, because why do we need it? And I think one of the things that often gets forgotten in the data conversation is, you know, and I'm going to put my data analyst hat back on here, because data is important. Data tells stories to a business. It tells stories to our investors. It tells stories to our customers. So we might have a reason to want to retain some of that data, but do we need to retain it in an identifiable status? Could we potentially look to anonymize that data so that the people aren't identifiable from it, but we can still, as an organisation, refer back to it and go, okay, so in the last 3 years, you know, we had a particular sickness record, you know, potentially due to COVID, which maybe impacted our, you know, our output and those kind of things. But, you know, so have a think about, do you need, if you do want to retain that data, do you want to retain it? Do you have that lawful purpose? But if you need, do you need to retain it in an identifiable status that identifies those individuals? So I think that's probably a really important consideration to make. Anonymizing data is potentially a really good step to take when you're looking at that historical data from an analytics perspective. Does that help?
How about, though, if we're talking health surveillance, drug and alcohol tests, whereas the whole point in doing it is that it's linked to a person?
Yes, absolutely. And again, we're looking here at the lawful purpose. You know, in some sectors, you will have a legal obligation to do that, and that would be your lawful purpose. I think it's making sure that you link it back to what is the purpose? Why have I got it? Ask yourself the why, and can you make sure that you identify that purpose for it? And is it necessary? Is it absolutely necessary? And can you get that data in another? You know, can you have that data in another way? So I think making sure you've got that strong lawful purpose is really important.
I think from a health and safety perspective, though, I'm kind of stuck in place here, because one particular place I've been working and supporting the past couple of years is Belgium.
Mm-hmm.
And even on a daily basis, we were not in a position to retain any data from the checks we did when somebody got to the gate at site. That was an absolute no-no, and it was confirmed by the client in particular as well, and not just from the government perspective in Belgium. But I guess what I come on to in terms of, you know, in some cases, I don't know whether we just store the data, whether that's the legitimate reason to store it. But certainly, if we bring in, for example, like employment law and your whole policies and procedures from a HR perspective, you may still retain information pertaining to alcohol and drugs sampling, for example. So it goes in somebody's work record, and that is legitimate reason to keep it.
Yep.
You know, you would naturally do it. Typically most organisations do it as part of an investigation, regardless, especially when people have been, you know, it's safe critical activities, scaffolders, etc., operating plant and equipment, etc., etc., etc. So, you know, I get that, but we may bring other disciplines in terms of how we retain information relating to that particular test.
I think that's the key, John. I think, you know, with the GDPR being that principles-based law, it allows you to do and fully encourages you to bring those requirements in from those other disciplines. Because, you know, so we've got that principle of only keeping data for as long as you need it, and it's those other disciplines that tell us how long that we need it for. So that's where it really the GDPR kind of complements and allows us to make those decisions based on those other elements.
And are you
and it also goes
that?
back to the transparency. Sorry, it just goes back to the transparency point as well. So people know how long that information is going to be kept for, whether it's going to be kept for 1 year, 5 years, 10 years, forever, which it should never be, but they're always aware of what that information's been kept for and for how long.
Mm-hmm. And are you handling that data differently to other data that you're collecting? So, you know, when you have health surveillance data, how are you treating it to keep it safe, as opposed to all the other data, maintenance of machines, that sort of thing? How are you handling it differently?
I guess it would depend, but certainly from an ISG perspective, and certainly from a previous employee in terms of, you know, it's commonplace arguably that, you know, first and foremost, every time you have a new project or account, a new contract, you go about creating a unique folder where straight away you are locking down people have access to that information that's stored in that particular folder, whatever it is now in the cloud, and that will be limited to various disciplines at various levels of persons within the organization, and typically no one from outside the organization has access to that. So, you know, if you think you've got an office manager or document controller, those kind of roles within organizations may then become the kind of like custodian in terms of where data is stored. Not specifically to do with GDPR and data privacy and all the data we collect from the various tests, etc., but certainly they will be one of the custodians and gatekeepers to maintain access.
It's interesting what you say about in the cloud, because I do have people who come to me thinking that it's safer to keep data in on-site servers than it is in the cloud. So John, I know you have a lot of experience. Do you have a feeling on this?
No, that's way too technical for me.
This is your job on the
line. Yeah, but you know, I think Alan touched upon this earlier in terms of small organizations may not have the same resources, and you mentioned from a legal perspective, the same applies, doesn't it? It doesn't matter if whatever organisation you are, whatever resources you've got, it's about maintaining suitable control of that data and information, regardless of where you store it, be it on a hard drive, in a cupboard somewhere, or in the cloud. It doesn't matter. All the principles apply, be it the 6 principles, including that accountability, right through to the whole kind of 6 lawful basis, I think you called it as well. So it's whatever's applicable to you and your organisation at that particular time. It's how you do it, but making sure you are compliant with that legal requirement.
And Anna mentioned as well, just following up on that in terms of the security of the data, she mentioned about doing a risk assessment. If you do an effective risk assessment, then that should be one of the questions that you're asking. And certainly if you look at the CNIL, the ICO websites, etc., for the supervisory bodies, they have templates that takes you through these risk assessments, and it gives you some guidance on things you should consider for data security, whether it be cloud, non-cloud, whether it be written down, etc., etc. So there's lots of guidance out there on how to keep data secure.
I think the one thing I'd add into the cloud thing. So I'm going to put, having done data analytics, I was an IT manager for a few years as well. So I like the technical aspect of it. The one thing I'd say about the cloud is you just need to remember it's someone else's computer. It's not floating around there being looked after by angels. It's literally when you put something, I know you love it when I use that analogy, don't you, Helen? But it's not, when you put something into the cloud, you're putting it onto someone else's computer. And but then you think, well, how do I find out how safe their computer is? If you look, so if you're selecting a cloud provider, my top tip, I always like to give kind of really simple operational top tips here, is have a look at their website, the cloud provider's website, in either their privacy policy, or they might have a kind of information security document that's available on their website, and they will tell you where they're going to transfer your data to. And you may well get a bit of a surprise. I've got all sorts of stories I can tell about organizations who send you data all over the place. And unlike us, so we need passports to travel the world. Our data doesn't need those passports. It can travel really, really quickly, across many, many borders. If you have a look at your cloud provider's website, have a look at the privacy policy or their information security document that will be on their website, it will tell you where they're going to transfer your data. And you can make a really quick decision then of, ooh, do I want my data going to, such and such a country? And it allows you to make that really quick, informed decision. So it's not necessarily as complicated as it can feel, and you can get a very quick sense by looking at that privacy policy or that information security document where that data is going to go when you put it in that cloud to be looked after by the angels.
Backstop question then. Are there examples of health, safety, environment managers being prosecuted for data breaches, and what were they? I guess Helen has the best overview.
We did a bit of research. No, we did a bit of research, Alison, before we came on here, and I've not found any prosecutions. They may be out there, and it may just be that I didn't manage to get around all the supervisory authorities across Europe. There are certainly some from, if I look in the UK, and this isn't just restricted, I'm sure this is happening in other countries as well, there's been some prosecutions of individuals within our National Health Service who have looked at records, personal patient records of families and friends. Now, just because they have access to data doesn't mean that they should access data. And there's a couple of cases, again, they're all in the public domain, where the individuals have been prosecuted. And again, the case has been successful because they accessed data they were not authorised to access. In terms of specifics against health and safety managers, I haven't found any. There may be some out there. Anna, I don't know whether you've seen any.
The thing I would like to add as well is that from an enforcement perspective, while there are some legislations that the individual can be prosecuted, it's always really important to remember that from the accountability perspective, it's the organisation that would potentially face some action if something went wrong. And it's where you've got your prosecutions against individuals, that can often be brought under the more localized laws. So for example, here in the UK, we've got the Data Protection Act 2018 that supplements the UK GDPR. So I think don't necessarily lose sight of the fact that actually, while there are some individual prosecutions, from the accountability perspective, the GDPR will be looking to enforce on the data control of the organisation, not necessarily the individual. So I hope that brings a little bit of a different context as well, because what I don't want people doing is going away and worrying about, oh my gosh, I'm going to be prosecuted. That's not what the law is there for. Absolutely not.
Absolutely.
And actually, the certainly here in the UK, it's very much around the intent. What was the intent? And where something has happened, accidentally, the regulator here certainly takes a very pragmatic approach on that. Prosecutions are few and far between, and if we go back to what John said, early doors, if you're approaching things with the right moral compass and the right reasons, the data protection law is not there to stop you doing things. It's there to tell you how to do things safely. So, I always like to kind of take that fear out of it almost. We have very much that, well, the data protection law stops us doing that. And actually, the way the data protection laws are framed is that it gives us the framework in which to act. And so if you find yourself feeling that the data protection law is stopping you doing something because of that fear of enforcement, check in with a professional on that, or check in with your supervisory authority like the ICO, like SNIL, because they will give you that advice on what can be done. It should not necessarily be used as a barrier. And certainly in a health and safety setting, it's there to ensure that investigations can go properly, and it should not be used as that barrier. So I hope that helps as well, give a little bit of a different feel to what we've been talking about.
That's really good to hear, because I'm used to like corporate manslaughter. You can go to prison, you can get fined.
That's not helpful, is it?
It's not helpful.
No. That's not helpful. And I came across this a few weeks ago. It used to be somebody would go to, can't do that. Health and safety says you can't do that. The phrase that Anna and I hear now is, can't do that. GDPR says you can't do that. I mean, you guys know as health and safety professionals that very, very, very rarely does the health and safety legislation prevent you from doing something, providing you've got all the right controls in place to prevent accidents. Funnily enough, it's not dissimilar from the world in privacy.
Yep. Then let's move forward and have a look at, a lot of people on this call are linked to IIRSM. So we're all running this sort of webinars. We're all trying to collect information on people. We've all got members who are IIRSM members already, and then people who come to our webinars who are not, and we would dearly like them to become IIRSM, to see the value and to join the organisation. So, it's an organisation, that's what it's trying to achieve ultimately. So what can we do with the information? If someone signs up for a webinar, what can we do with their data? Can IIRSM store it on Excel or in a CRM? Can a branch store it? So can I store data of who's coming on this webinar? Does it make any difference if that person is a IIRSM member or not? Can we contact them in future if we have another webinar or another event? And most importantly, what can we not do with their data? Please, I would love to know.
I've got to say this, haven't I? It depends. Yep. It depends what you told them you were going to do with their data, Alison. Absolutely depends. So
depends what's in the privacy policy.
Depends what's in the privacy policy. Depends what you said when they were going to join this call.
I don't think anyone is reading a privacy policy before they sign up for a webinar, to be fair.
No, so there's a couple of different things you can do. One of them is, yes, you can ask for consent. So consent to be added to a mailing list, something like that. Certainly from our perspective, if somebody was to attend one of our one of our Risk Evolves webinars, then we use the basis for legitimate interest if we're going to then tell them about more webinars that we may be hosting. But one of the things we'll also say that we will not do is we will not sell their information, and we will not use their information for purposes that are not related to what we're doing today. So it really depends on what you're going to tell the individual, the lawful basis that you're going to use, and how you then communicate that with the individual as well.
So you said,
can I just add something?
Go on, sorry, John.
Can I just add something? And this is, if a member or non-member for this webinar and just accessing the IIRSM website or any other websites, straight away you are linked, you are drawn into allow, reject all, reject some, etc. So straight away you've got that kind of ask, haven't you? The organization's asking you, and just by accepting all cookies, then straight away that organization has got the right, a legal basis to retain information that's capturing from you just clicking on that website. That's a starter for 10. So then it's the day after, when you, because you've been on the JD Sports website, whatever, looking at some new trainers, the day after when you get umpteen emails coming through, all you've got to do is go straight to the bottom and unsubscribe, because straight away that's what it's doing, just making those connections. That's, I think, something we take for granted. And I'm pleased to say, and I know this, not the detail, but as a trustee of the IIRSM, we have got those basic controls in place. So a member or non-member straight away has got that right to unsubscribe, but they've allowed the IIRSM to retain some information and data based on that principle.
Okay, going one step away from that. So I'm the chair of IIRSM Europe. I find out who comes on this webinar. What can I store this data? I as IIRSM Europe, or I as Alison Hind? And what can I do with that data to promote Europe?
It really does depend, Alison, on what the delegates have been told you're going to do with that data.
And I think you made a really good, interesting point there, Alison, by separating yourself out from IIRSM to Alison Hind. So certainly as IIRSM, it depends what you said, but certainly as Alison Hind, they wouldn't necessarily have given you permission as Alison Hind to do something for your purposes. So it's all about, you know, the what's reasonably expected. So by coming onto the IIRSM call, I would reasonably expect that IIRSM would then potentially contact me, but I wouldn't expect Alison Hind to contact me. And actually, the law does actually say about what an individual would reasonably expect. So yeah, separating yourself out was quite an interesting way of doing it. So be very, very, you know, it's just approach that with caution. But it, as Helen says, it depends on what the individual saw when they signed up for the webinar. Helen, how many times have we said it depends?
I don't know.
I'm delighted that we have Julie as our, I don't know, helper. I don't know what she's called. Probably
the network
facilitator.
Facilitator. Yeah. Because then the problem becomes hers. Yeah, and it is really difficult when you're trying to grow our branch, where the lines are on this. So I'll just
we'll have a chat offline. We'll have a chat offline, Alison. We'll give you some hints and tips.
Yeah, I'm quite happy to take it.
I bet all the other branches have exactly the same issues as well. You know,
really another webinar coming on.
Same here. Yeah.
It's on a serious note. I'm quite happy to take an action away, because in the background, as a group of trustees, supported by those working within the institute and others where appropriate, we are going through, I guess, a behind-the-scenes process to make sure we've got all the right checks and balances in place. And it's quite all-encompassing what we've been doing. It's been enlightening to me as a trustee of the last 16 to 18 months or so. But I'm quite prepared to take an action away, because it's on the to-do list anyway, to come back and give you and all the other chairs of the IIRSM branches confirmation of what we do and do not do, and what's within your right to do as a branch chair, and obviously your deputy and your committee as well. So I'm quite prepared to take the action away for that.
Yeah, thank you very much. It's always interesting as well to know who would be on that list. So I guess Julie has a list for our members and our people who are interested and have come to our webinars, and so she has those two lists. And then I meet someone else, and I don't know if they're on that list or not. You know, I go and have coffee with them. They're interested. How do I put them on those lists? How do I know if they're already on that list? That sort of question. So us as chairs as well, having access to who is on these lists, but not necessarily us keeping that list.
Yeah, from an attendee's perspective, I don't know. I wouldn't profess to know, but from a speaker's perspective, you know, if we're reaching out to speakers to support the IIRSM and the wider community, then just by pure invitation to that individual, that group of people, they will then know that they're going to go on a list, and that list is only accessible to certain people, duly in particular, arguably. Even as a trustee, I don't have access to lots of information because that's not my right as a trustee, unless there's a legitimate reason, legitimate basis, I think the word is, in terms of access to it, but typically it's not. So I guess it depends. If it's somebody who's just signed up for the webinar, it's subtly different. But like I say, I'll take an action and I'll follow it through for you. So depending when part 3 is, we can give you a response to that, can't we?
Very aware of time, Alison.
Yeah, I was going to say, I think we're aware of time, aren't we?
Yes, yeah. Oh. All right, can I just do one last, because it's come up on the thing, it's from Dominic again. What do you think of the current state of data privacy laws? Should these laws be made more or less strict? In one word. And does it depend?
It depends.
It depends, yeah. And I guess, Dominic, it'd be interesting to know the scope. Are you talking about the UK? Are you talking about Europe? Are you talking globally? Is there a specific location and country that you're thinking about? So it depends. It really does depend.
I think the one thing I'm very conscious of time. The one thing quickly that I would add is here in the UK at the moment, there is the new data privacy bill that has been reintroduced to Parliament, which is looking at potentially some changes that the UK government might want to make. I've seen a little bit of excitement around that. Anybody who is on the call that is UK based, UK GDPR still applies. Any changes are a long way down the road. So let's just kind of watch that, you know, keep that on our periphery vision, but let's just kind of make sure that we keep focused on coming back to John's words, what's the right thing to do? I think we get very lost in the legislation, and you know, we can get into the weeds of those kind of things, and let's just, you know, remember to try and focus, what is the right thing to do? You know, let's keep that moral compass as strong as we possibly can.
How about you, John? More strict, less strict, keep it as it is?
3 words, why wouldn't you? So that's kind of sitting on the fence, but why wouldn't you do what we're doing today?
Yeah, yeah. Do you know, I think that sums it up. I think that's a great finishing line. So thank you very much. Thank you, everyone. I know we've run over a little while, but to be fair, we did last time as well. And I've enjoyed the conversation. I hope everyone else did as well. Thank you very, very much for joining us. To Helen, to Anna, to John, and to everyone who's here on the call from, you know, please do, as I said, we're trying to get more members, IIRSM Europe. It's the way to go. Thank you, everyone. Thank you.
Thank you.
Thanks all. Bye-bye.